weeks. Today's training is on sexual harassment, and we have two facilitators with us who comes to us from the Law Society of Kenya. They are going to tackle various topics regarding generally the overview of sexual harassment, perhaps in Kenya, taking consideration elements of sexual harassment, bullying, and marrying that together with the legal provisions, as well as what institutions can do in order to curb such a vice within the organization. Now, allow me to introduce to you our presenters for today, who will be taking us through this particular subject. We have Advocate Beth Michoma. Beth Michoma is the chair and the convener of Gender Committee by the Law Society of Kenya. She is an advocate of good standing in Kenya as well, and a member of the Chartered Institute of Arbitrators Kenyan chapter. Equally joining her for the session for today is Luande Vit. I hope I've pronounced your name well, Wakili. She's also a member of the Gender Committee by the Law Society of Kenya, and equally an advocate of good standing, advocate of the High Court in good standing in Kenya as well. My co-facilitator today will be Vanessa Tabut. So we hope you'll enjoy the session, and it's going to be a fruitful discussion. Now, I want to introduce perhaps Beth.
Good evening. Good afternoon, sorry. Unfortunately, Beth won't be joining us. She's unwell, she just fell unwell. But Yvette will take over the presentations. We want to thank you again for partnering with us. This is a very important training, and the conversation is designed at recognizing and dealing with sexual harassment cases to create a conducive environment for all employees. So I'll just introduce Yvette, who will take over after I've introduced for the presentations. So Yvette is an advocate of the High Court with 8 years experience in research, human rights and constitutional law, labor and employment law. Currently a researcher at the Judiciary of Kenya, a partner at Dunlex Partners, and a member of the Gender Committee at the Law Society of Kenya for the past 4 years. She was part of the team that drafted the sexual harassment and anti-bullying policy for the LSK, the one that we're using right now. And currently she's undertaking her LLM at the University of Nairobi with a special focus on gender and the law, whilst researching on sexual harassment in the workplace. So Yvette Luande, I will welcome you on the floor.
Thank you, Vanessa. As you heard, my name is Yvette Luande. I had a presentation, which I hope I'll be able to share with you shortly. Give me just a minute. Okay. So sexual harassment in the workplace. I see we have about 1.5 hours. So I'm hoping I'll be able to take you through maybe 45 minutes and have another 45 minutes for interaction and questions. So just starting off, I'll give you a brief background as to sexual harassment in Kenya and how it came about to be law and how the discussion started happening in Parliament. So in 2006, we had the Sexual Offences Bill, which was tabled in Parliament, of course. And the aim of that bill was to criminalize or to increase penalties for sexual offenses. So at the time, we had the likes of Martha Karua, who were advocating for sexual harassment to be part of the bill. And so yes, we had male members of parliament opposed to this tabling and for sexual harassment to be included. According to them, it would deter our African culture, which would deter marriage, or if you're trying to seduce a woman, or the perceived notion that when a woman says yes, when a woman says no, they mean yes. So immediately in 2006, it was struck down. But since we were able to pass it through the Employment Act of 2007, it was passed without discussion, so without much discussion as it was in 2006. So we had at least one section of that particular act addressing sexual harassment. So briefly, I'll get to the law in time, but I just want to take you through definitions. What is sexual harassment? So sexual harassment, obviously, I'll start with the definition, international definition, and one of the definitions that I favor, then I'll go to the Kenyan law. So sexual harassment means unwanted conduct of a sexual nature, of course, or other conduct based on sex affecting the dignity of women and men at work. That is the definition given by the International Labour Organization. It is any sexually oriented conduct that may endanger the victim's job, affect performance, or undermine personal dignity. So taking these definitions into consideration, then we come into the law in Kenya. So when we look at the Sexual Offences Act, the notion behind it was targeting people in public office, people in government. It wasn't really targeting employees or the common wananchi. It was basically targeting people in parliament and government. That's why it's phrased the way it's phrased, that if you're in a position of authority or if you hold public office and you persistently make any sexual advances or requests which you know or have reasonable ground to know are unwelcome, then you're guilty of sexual offenses. If you look at how this section has been phrased, it's a bit political because it says that it has to be persistent. You have to have reasonable grounds to know that your advances are unwelcome. That's when you shall be liable to imprisonment for a term of not less than 3 years. And I have looked if there's been anyone who's been convicted under this section, and I have not found any. So it was very vague and the standards were so high that, it has to be persistent, that it's not enough that you groped someone once or committed an act once or twice. It has to be continuous, persistent. And so we go to, you have reasonable grounds to know. And we know by just the nature of sexual harassment, many people take it, you're quiet. I guess it's also shock, but the first time it happens to you, you're not sure, did that just happen to me, or what is it that I've just gone through? So it puts a ground that you have to know your conduct is unwelcome. So one, you have to either voice or state that this behavior that you're taking part in, I don't want it, I'm not participating. So it brings in the nature of consent, which it puts a burden on the person experiencing sexual harassment that you have to speak up, you have to say no. And most of the time, as we know, and as we've seen even with international cases, the Bill Cosby one, it took about 29 years for some of those ladies to speak up. So at the initial time it was happening, they were, They did not oppose or reject his advances. 29 years later is when they're saying, we did not want this to happen to us. So then it puts the ground of reasonable grounds to know if you are the perpetrator. Just housekeeping rules, I'll be referring a lot to a perpetrator, and that's the person who is making advances or perpetrating this sexual harassment, and the complainant or the victim. So just a note to everyone. So it puts the perpetrator is in a more advantageous position because the victim has to prove that they made some form of rejection. The perpetrator had reasonable grounds to know that his advances are unwelcome. So like the members of parliament were saying, that in African culture, when a woman says no, she means yes. And it's a form of endearment or bonus points on the woman if you say no many times. So to the mind of this gentleman, as the members of parliament were trying to put it, that they did not know that when you are saying no, you actually meant no. So on that ground, they could not reasonably know that you actually did not want the advances. So this particular section, section 23, is very difficult for anyone to get redress. And so we move on to the Employment Act. And one more thing is just that it could be both ways, men and women. I'm not taking any biased view, but I'm just reporting what was said in Parliament with regards to the male members of Parliament trying to say that it's the women who, are playing hard to get. So both men and women can, of course, experience sexual harassment, no bias from my end. So the other law I want to just bring to your attention is the Employment Act 2007. So 2006, we have sexual offenses. 2007 comes the Employment Act. So under the Employment Act, the main section is section 6. And this section was monumental, especially for employees. An employee is sexually harassed if the employer of that employee or a representative of that employee, of that employer or co-worker, directly or indirectly requests that employee for sexual intercourse, sexual contact, or any other form of sexual activity that contains an implied or express promise of preferential treatment in employment, threat of detrimental treatment in employment, threat about present or future employment status of the employee. So this is one of, just part one of that definition brings about the whole concept of types of sexual harassment. The easiest and most definite one that is so easy to pick out is this part, which is quid pro quo. I'll discuss it later, but it means quid pro quo means tit for tat. You give me, I give you. So it's that if you give me sexual favors, you will get a bonus, for instance. You'll get a promotion, you'll get better sitting space, so tit for tat. And that's what the law is talking about here, that I indirectly or directly request for sexual favors in the promise that you'll get some preferential treatment, or in the alternative, that if you don't get preferential treatment, I will fire you, I will demote you, I will prevent you from getting bonuses, I will leave you out of, projects, or that you will not be able to work again in this industry. I suppose maybe now in the medical field, you will not be able to be employed anywhere else, any other hospital, because They have gone around and they have ruined your name. So this is quid pro quo. That is tit for tat. That's the first type of sexual harassment. So this other part of harassment is creating a hostile environment in the workplace. And so the Act defines it as using language, whether written or spoken, of a sexual nature, using visual material of a sexual nature, and showing physical behavior of a sexual nature which directly or indirectly subjects the employee to behavior that is unwelcome or offensive. And that goes to the definition of what sexual harassment is. It's always unwelcome. It's always offensive to that employee and has a detrimental effect to the job performance, job satisfaction, or their employment. So part 2 of sexual harassment, other than quid pro quo, is verbal, visual, physical. Now, using language, for instance, is, let me give an example, obviously, that these sexual jokes that people like to, tell in the presence of people. You're talking about obscene things or, sexual positions. So, or just always using colorful languages or describing someone's body. And when it comes to visual material, we have a case in the US of a gentleman who used to put up pornography in his workspace. And his defense was that it's my workspace. If you come to my desk, then you are consenting to look at these materials. I'm not asking you to come to my desk. And so that's, the court there viewed it as sexual harassment because it's visual. Or the way people send videos as well on their phones. You forwarded someone a video without them asking for it. You just impromptu shared some picture of what was in the news the other day, for instance, a video of Mukisa Kitu, for example, that does amount to sexual harassment. So I shall come back to the Employment Act, just to discuss case law, but I just want you to have in mind that it could be verbal, it could be physical, and physical is obvious. Okay, it's not so obvious because it could be that you've been groped. That one is obvious, but I know a case where a man used to just brush himself against the ladies as they're passing, or as they pass through a door, he makes sure that he's near the door so that you're squeezed and he rubs against you. So some of them can be very subtle. And so that kind of physical behavior can amount to sexual harassment. So the other law of importance is the Occupational Safety and Health Act. And the UN has declared sexual harassment as an occupational safety and health hazard. And in our law, Section 8 talks about you can't dismiss an employee just because they reported or made a complaint about a matter that there's something going on in the workplace that is detrimental to their health. And this I'll discuss later will be the effects of sexual harassment, which is, an issue of mental, psychological torture, and that still comes to health. And obviously, all of you would know better than I would, psychology of health, how it becomes an issue of you have physical illness that coming from stress, your gut is all over the place or your hormones are all over the place. So it becomes a health issue stemming from the workplace. and that takes care of an issue which will come at a later time, which is that you're not supposed to retaliate against anyone who has spoken out against another employee or the company itself. Okay, just as I was talking about, these are the categories I was talking about: quid pro quo and hostile work environment. Every definition in different countries has to look at quid pro quo and hostile work environment. So quid pro quo is when a job benefit is tied to these sexual advances. And most of the time it's from a supervisor to a lower level or people who are under him or her, because they have the ability to influence the outcome of your job. I mean, a fellow employee or a fellow colleague, let's say a doctor and a doctor on the same level, it would be very hard for, I guess, I stand to be corrected, but for them to say they're firing you. Maybe, so there has to be a hierarchy where someone who is above you is the one who is trying to impact your job negatively or offer these benefits. So quid pro quo is mainly hierarchical in vertically, so top to bottom. Hostile work environment, on the other hand, occurs when an employee is subjected to comments of a sexual nature, offensive sexual materials, or unwelcome physical contact as a regular part of your work. Obviously, as I've said, quid pro quo is easier to pick out because it will be simple to show that normally in this company, people progress after 5 years, or these are my accomplishments. These are the people who have progressed, I have not. So based on the fact that I did not submit to ABCD, then this company, I ought to have expected a raise, a bonus, promotion, but I didn't, on account that I did not give in to some sexual demands. But hostile work environment, on the other hand, is so subtle or can be so permissive that it needs more attention to just isolate it. So there are, for instance, the things that the court will look at. Yeah, sorry, the things that the court will look at. A single incident, which is isolated, might not be considered to be a case of hostile work environment. Let's say today I told someone, let's say I used colorful language, or I said, fuck you, forgive my language, because I need to be able to just show you some, or to demonstrate some things. But that one incident might not be enough to say that I faced verbal sexual harassment. So the court, for one, will look at how persistent is this behavior. But you see, there could be some like physical that is so extreme and so egregious that it is, on the face of it, sexual harassment. If someone came and touched your genitals, that is so extreme that you won't be waiting for it to happen a second time. There's no need for the qualification of persistence. It is that one time it happened is enough for it to be sexual harassment. So yes, as I was saying, the court will look at whether it was persistent or a single isolated incident, which is not extreme or egregious. Then the courts will also look to see how serious is this conduct. I'm not trying to say that there are some that are worse than others, but there are. if we're talking about sexual assault, that one stands higher or would be more serious than someone gave you a hug without your consent. Yes, violation of personal space at a different level, but this one, the one for the hug, would be someone who comes every day. I say, please don't hug me, but they force themselves on you. So that one would be obvious. It's persistent every day that it happens and amounts to sexual harassment. So hostile work environment can also be difficult to distinguish because it comes from daily or routine relations or your work culture. For instance, there's a case in 2017. I don't know, those of you who are privy to Ushahidi, it was posted online. But this Ushahidi case, the lady who ended up leaking the trial or the work investigation by Ushahidi, said that she used to use, in the office, they used to use colorful language. It was normal for them to say, fuck you, or for them to tell like dirty jokes. And based off on that, saying that a colleague took it too far. So you see, according to her, the work culture, how do you distinguish between the work culture? We can tell bad jokes, show videos as bad as we want, and then one day someone comes and say, sorry, just a minute. I am being told I should use the slideshow button. Sorry, everyone. Let's see. Where is that? Just give me a minute. Here. Okay. Wonderful. Okay. Let's see. I was talking about hostile work environment. I hope this is better for everyone now. And yes, so I was talking about why hostile work environment can be really easy to slip through our fingers or need more scrutiny. So as I said, the work culture plays a big role in determining what is normally admitted in that particular. It's so specific to that organization that you can't use an objective standard, or it's part of social relations. Oh, we're Italians, we hug in this organization. So you Kenyan, you have come here and you don't do hugs. You see, so it's part of the norm in that organization. And these hostile work environments, sometimes they don't have the economic consequence. You see, quid pro quo, it's that nice job here, you didn't get a bonus, sometimes they even fire you. But this one for hostile work environment, it doesn't have economic consequences. And people are acting in their own interest, not the interest of the employer. So sometimes the court has to look at, was the conduct verbal or physical or both? And it also looks at, was the conduct offensive? Because sometimes we can have your conduct is offensive, but does not amount to sexual harassment. So is it persistent? That one we've discussed. Were there other people who joined into that belittling of that person? Was it done by a person in authority? Was it targeted to more than one person? So the court has to really look at circumstances as a whole. You can't just say these are the standards. We have to look at the organization, the circumstances of what happened, how it happened. So it's the second type of sexual harassment, the hostile work environment, needs to be critically analyzed by a court of law or by the investigating team, let's say in KNH. So I wanted to just bring to your attention some case laws. Normally, so this is CAS versus CS Limited. And this gentleman took the organization to court. And sorry, let me just, yeah, let me come to case law later because it impacts some of the things I'm going to talk about a bit later. So let me just go to key things to remember when defining sexual harassment. So there has to be a sexual conduct. It has to be unwanted or unwelcome. And I've put here what is things to think about that the law and different jurisdictions are grappling with is what is unwelcome conduct? What is the legal test of such and such behavior is unwelcome? Some jurisdictions say, did you say no? Did you tell someone that this was happening to you? And some scholars say that that goes up against the feminist thought, or is victim shaming, because as a victim, it takes so long for you to come forward with some of these things. So you can't be pegged on, did you say yes or no? The other thing that is normally discussed is some people are just sensitive. I know of a lady who, touching her knee is for her sexual. So, there've been articles like, learn to take a joke. And so how does it, if someone is reporting that they've been sexually harassed, are they just being sensitive, or is it a case of actual sexual harassment? So there's been also talk of a reasonable person in the sense of how to tell if someone is sensitive or not. Would a reasonable person, a right-thinking person in the same situation find that this behavior or this conduct meted against them to amount to sexual harassment? Does a reasonable person in that same situation think that that is sexual harassment? And some jurisdictions have gone a step further. I know there are cases in the US where they've said, what or who is a reasonable person? A man and a woman perceive situations differently. A woman can say, that is a behavior that is a no-no. And a man will be like, no, I was just being friendly. So there has to be, again, other than a reasonable test, it would be the male test versus the female test, the reasonable woman test. Because statistics have shown that women undergo sexual harassment more than men. So it's only fitting that we have a reasonable woman test that would, a reasonable woman in that situation who has faced sexual harassment or tends to, it's women who, if you grope a man's chest, that's nothing, but a woman will perceive a situation differently when it comes to groping their chest. So would a reasonable woman think that that is sexual harassment? Would the fact that you are in a relationship with someone amount to sexual harassment? Because now you used to be in a relationship, you've broken up, or you used to be married, now you're divorced, and this person is trying to rekindle the flame or trying to connect, and then you start claiming sexual harassment. Or you normally flirt, you have a banter, that is sexual, but one day you decide, apana, this person has gone too far. Or how far do we go with dressing? This issue of my dress, my choice. A man comes into the office with hot pants underneath their, the medical robe. Do they call it medical robe? I think it's a medical coat. Is that provocative dressing to other men or to women, for instance? Is that supposed to be considered when you're filing a sexual harassment claim, that you normally dress very provocatively? How then can you claim that you're being sexually harassed? And is the fact that you're being provoked a defense to sexual harassment? Yeah. So on some of these issues, now they haven't come quite in Kenya that I know of, but these are some of the issues I've seen in cases outside. That regardless of how you dress, you are still entitled to an environment that is free of sexual harassment. My dress, my choice is actually a right, that it's not an entitlement to be harassed. Whether male or female, you can wear your muscle shirt if you please. That does not entitle women to catcall you. The fact that you normally have provocative speech doesn't mean that one day someone has a right to come and cross the line and tell you sexual things because you normally tell dirty jokes. That the fact that you have not said no explicitly, N-O, that someone can take your behavior to be welcoming. So these are the issues that crop up when you think of sexual harassment. Yeah. When it comes to workplace related, if you have, let's say, a meet and greet for interns and doctors or nurses, for instance, after work, a hard day, you have maybe KNH is sponsoring a dinner or a gala. Does the fact that you're not in the hospital, if someone harasses you there, are they still within the confines of that I can report to my employer that I was harassed? And definitely you can. So cases have shown, as long as it was 9 to 5 and you are still within an activity that involves the organization, the mandate of the organization is still to cover you even when you go to events that are not within the confines of the hospital or your work environment. So even if you do harass someone there, it's still sexual harassment. Okay. So here I'm setting a few questions in light of what I've said. Questions that maybe think twice when given the definition of sexual harassment, what we need to be careful or just consider. For instance, asking someone intrusive questions about the sexuality. Are you straight? Are you gay? Oh, you're gay. What do you do in the bedroom? Who did you used to date? Or calling someone a lesbian can amount to sexual harassment. You don't even know their name. It's just as in lemon or lemo, So suggestive comments about someone's body shape, kona figure 8, unaka poa, day in, day out. The thing is, remember, is it unwelcome? Does someone just cringe or their face just, or they try to avoid you because day in, day out, it's how nice their ass looks or how nice they look in those jeans? So the point is persistent. Is it unwelcome? You're there just, thinking you're giving compliments without knowing whether this behavior is unwelcome or not. And that is where you also need to read, cues. After they've declined, tumemaliza shift, si twende dinner, sikuja kwangu. Asking someone if they're on family planning, which is very personal. Why are you planning to ask them on a sexual date? I don't know. Asking someone to pass by your house to discuss a patient. If you promise someone a raise or certain benefits or nice, what do they call them? Locum benefits, I don't know. If you do this for me, I'm going to be giving you nice rounds, or you want to go to this department for your rounds, you'll be going to this other place. I'm just trying to think of best scenarios. Yes. WhatsApp groups, these ones have become notorious. No one has chosen to litigate yet. Those people who share pornography, sexual pictures, I don't know, pictures of your boobs to the work group, please stop. It can amount to sexual harassment. In fact, that is the worst, it's sexual harassment on a large scale level. And you're constantly doing it. Remember, persistent, unwelcome. You've been told in the group, please stop. This one, I already discussed the case in the US, putting photos of nude people in your locker or on your desk, where other people come to see, or you're watching porn in the office. Other people have to listen to you watching porn. Some strange behaviors. Or if you've been coerced, let's say you've been told that if you don't have sex with me, I will not give you a promotion, and then you voluntarily accept to have sex with this person. Does this mean that you have not been sexually harassed because you consented? It is still harassment, by the way. You can still win such a suit because you have accepted, pegged on your detriment to your job. Sorry, let me just look at the time. Okay, let me move it along. Yes. And just because people after a shift go to a bar, and this one person does not want to go to a bar, you keep asking and pushing that it's going to be in public. It doesn't matter if it's in public. It can amount to sexual harassment if now you're berating them, or it has some sexual tag to it, and you start talking about, remember, it has to have a sexual conduct attached to it, not just harassment, but sexual harassment. So in this last one, constantly asking a colleague to join you and other colleagues to get drinks at a bar after work. This one, if there's no sexuality pegged onto it, then it becomes harassment and not sexual harassment. Okay, then I go to the need for an internal policy, which was something else I was supposed to address. Why would KNH be required to have a sexual harassment policy? The law requires it, obviously. As we've read in Section 6 of the Employment Act, if you have 20 or more employees, number one, you have to consult with your employees and issue a policy statement on sexual harassment. Now, this number 20 is very random, but at least for KNH, I'm sure you're more than 20 of you. So by law, you are required, KNH is required to have a sexual harassment policy. Failure to have a sexual harassment policy results in a fine of only 50,000 or a jail term of not exceeding 3 months or so. Now, you see, it's a jail term. KNH is an institution, a big institution. Who are you going to jail? So that is, I guess, to the discretion of the court, but it was targeting small companies. Even the fact that they're saying, if you're below 19, you don't have to have a sexual harassment policy. It's as if sexual harassment does not happen in small organizations. They just think it happens in big organizations. Nonetheless, we're happy that the section exists, even if it has some deficiencies. So the law is also clear as to what a sexual harassment policy might contain. You can put all other things, but these ones are fundamental. The definition of sexual harassment. They're not saying it has to be as crafted in the act, but put a definition for what your amounts to your sexual harassment in your organization. Remember, each organization has a culture, so definitions might change here and there. You have to declare that Kenyatta National Hospital is an environment free from sexual harassment. And should we find sexual harassment, we will take steps to prevent it before it happens. Tell people that there'll be disciplinary measures, how complaints can be brought forward, and that there will be non-disclosure of the complainant, which will be addressed later. But basically, once you complain, KNH cannot go advertising that so-and-so filed a complaint. It's an offense in itself against the organization. You can claim damages. In fact, if at that stage of you even submitting a complaint, it's all over social media, and you know you gave it to the HR department or the legal department, and all of a sudden, everyone knows that this doctor filed a complaint against this doctor. So non-disclosure of the complainant, which I'll talk to you about a case later on about non-disclosure, but basically this is what has to be contained. Is KNH or an employer liable for hostile environment harassment or for sexual harassment? Let me say it like that. And the answer is yes, vicarious liability. You are responsible for the acts of your doctors, nurses, I mean, everyone under you. That's what vicarious liability is about. By virtue of you employing them, you are hosting where they work, then there are some acts which, if they perform, it is on you. But there has to be, there are of course exceptions to vicarious liability applying. As I've said, it's going to be applied if your supervisors, managers are responsible for the hostile work environment, you did nothing to address, prevent, or correct that behavior. Or there's a case still on Ushahidi that they're saying that the board, this lady reported to the board, and it took 74 days. 74 days for them to do an investigation, to do a hearing. 74 days, according to now, this person was too long, because by that time, think about it, that's about 60, that's 2.5 months of going through, you have to go to the same workplace as this person you've reported. So sometimes time is a factor. So in such cases, the employer will be liable if they did nothing or dilly-dallied in giving you, they've just been taking you round and round with your harassment claim, telling you we are considering, telling you come again, get an advocate, write it down, have another meeting. By the end of it, you're even tired. So if an employee can show a court that, this is what is missing, then, and you fail to take advantage of what KNH has been offering, then the employer will not be vicariously liable. So I just wanted to give you case law, just in light of everything that I've discussed. I think we're still within time. Yes. So in this matter, the CAS versus CS Limited, this company had a code of conduct. They had a provision saying how sexual harassment is not permitted in this organization. And even though the employee the court did not answer her allegations of sexual harassment. And that's, yes, the court did not answer its allegations on sexual harassment, but the employer was found guilty of failing to have a policy. And it was ordered to appear to court to answer the charges of not having a policy. Remember, it's against the law not to have a policy if you have 20 or more employees, and you're liable to 50,000 fine. and you're liable to 3 months imprisonment. But the court also, normally what it does, it gives orders of accountability. Then if you fail to comply, additionally, how the courts are going around it is to be contempt of court. That we told you by this date, you need to have this policy. In addition to these fines we've imposed, you have been in contempt of court. See? The second case of Joseph Kairu Mutahi versus British Army Training Unit, Kenya. This gentleman had, what do you call it? Received complaints against him from various women of sexual harassment. So the company fully has a code of conduct, which also talked about that it's a gross misconduct. And then in the documents he'd been given, the names of the complainants had been redacted. Remember, we had said that you're not supposed, there's confidentiality, which is to be discussed in a different webinar, but it means that you're protected from retaliation. So this gentleman received complaints. He went for hearings, and people have said you did this, this, and this, but about where it says the name of the person, it's been put in black, redacted. He doesn't know who these people are, and he's been suspended. So justice works both ways. It's true that the rest of the world should not know that you filed a complaint, but the person against whom a complaint is lodged has the right to know who exactly has lodged a complaint against me. Because how am I supposed to respond that on a certain day I was in the office, mind you, with 50 women or 50 men, it could be any one of them. So I need to be able to specifically respond. So in this case, other than finding that this company's sexual harassment policy did fell short of what was in the act, the court said that the preliminary investigatory proceedings must also include the name of the people who made the allegations. It must be given to the person the perpetrator, the alleged perpetrator. They're entitled to know the identity of the complainant so that the ends of justice can be met. I have another case here of NML versus Peter Patrouche. This one was a general factotum, a house help, and hers was extreme sexual harassment. It was a German gentleman, and she went through everything, to him filming her when she was showering, calling her a monkey, touching her breasts to see if she's pregnant, or inserting his finger to see if she's pregnant. It was intense harassment, physical. And you see, this is one of the ones we were talking about. If it just happens once, it's enough for sexual harassment, but this lady really went through the ringer. And so the court stated that his acts amounted to sexual harassment, and she was given 1.2 million for it. And that in addition to, now she was fired eventually, that sexual harassment damages or general damages which are awarded are different from a claim of unfair termination. First, you sue the person for unfair termination, and then you also sue them for sexual harassment. So you can claim under both heads. The next one, the last one, is PO versus Board of Trustees, AF and two others. This lady was employed in a company as it was an NGO where she had to go traveling around. They went to South Africa, and on the trip there, she went with her manager. And it only happened once when they were in South Africa, that this gentleman started telling her how beautiful she is, touching her. And when he booked a room, turns out there was only one room with one bed. The lady slept on the floor. The guy was so pissed, he boxed her and started sending her offensive emails as to how he will terminate her. And when they got back, since it was just the two of them, he put out a memo that she had, due to misconduct of when we went to South Africa, you're hereby terminated. So she got an award of 3 million for sexual harassment and unfair termination. So these are just some of the claims that, on the one hand, it is very vital for employers to protect their employees from sexual harassment, not only because it offends the dignity of the person. It can be because, no one should have to go through behavior that is offensive, humiliating. Sometimes it's just to put someone in their place. It doesn't have to be sexually motivated. There is sexual conduct, but it's motivated by putting you in your place, humiliating you, and just lowering your dignity. So to that end, and to the effects, which I will list here, it's just employers are obligated, and the state is also obligated. Not only, vertical and horizontal, the state must protect, the employer must protect the individual from sexual harassment, but employers must also protect themselves from sexual harassment suits. You want to show that you did everything for your employee to avoid this behavior. And that way, the employer can, if they took all measures, they transferred this person, put them on probation, that there was a mechanism to report, which will be handled at a later seminar, webinar, but that you took all precautions to help your employee not to be harassed, then that is the standard that the courts are looking at. The effects are on the screen here, and I'm sure there's so many, first is just loss of dignity, lack of confidence. You would rather quit than be harassed. Sometimes you're ostracized because you reported someone. You lose employment. The business itself suffers because some doctors or nurses will resign, or members of staff will resign. You're always high turnover. You're always trying to fill places. Work is not moving the way it needs to be. You'd rather just stay at home than be sexualized here and there. Decreased job satisfaction, mental, emotional, psychological effects, which results also, in diseases. In the Ushahidi case I'm talking about, this lady was talking about her gut. She had gut issues, headaches, migraines, which, she goes to the hospital and no one can pinpoint what the problem is, but it's because of sexual harassment in the workplace. Poor work performance are just some of the things which, people are going through. And I think that is the end of my presentation. I think I'm within time, 3:05. Very good. We have some time to just look through. Yeah. Thank you.
Thank you so much, Yvette, for that presentation. It was a really, really interesting presentation. I'd like to hand over to Sarah Okumo to take over the question and answer session together with Vanessa. Thank you.
All right. Thank you so much, Yvette, for that. So we have a couple of questions. I hope we can get through them all, but so first is, someone is asking how to report sexual harassment as a government worker. They've tried reporting and the systems have failed terribly.
Sorry, would you like me to tackle one by one, or maybe we can do two at a time?
Okay, sure, that's fine.
Okay.
I'll read another one. Another one is, if one keeps trying to get you to meet outside the work environment, is it still sexual harassment?
Okay. I'll go to how to report. Sorry, it was how to report as a male doctor. What did I?
As a government worker.
As a government worker.
Yes, they say that they've tried reporting and the systems have failed.
Okay. This one, I would say, it's coming. There's a different webinar on how to lodge a complaint of sexual harassment. But I would say, just generally, first, you need to bring it to the attention of your employer, which, judging by how the question is phrased, it was already done. If it is in writing, or you've documented that you've tried to reach your organization, then as a government worker, the next thing to do would be to sue your employer. If it's the judiciary, sue the judiciary. If it's the Ministry of Health, sue them as well. And the individual, which is, I hope I'm not speaking out of turn, but yes, this is just, if systems have failed, then you go to the court system. Yes. Then for the second question, if this person is a colleague, it doesn't matter if they're asking you to meet outside of work, as long as our relationship stems from work or our daily, meeting because of where we are employed, it is still sexual harassment, and your employer has the obligation to deal with it, and you report it to them. That it's been persistent. I've said no many times, but this person just keeps coming at me. And the reason we're only in contact with each other is because we work for you. So you deal with it. Yes.
All right. So I'll read 3 others that are similar. So what can you say if someone asks you about your personal life, including romantic or sexual experiences? Or if I were to smile at a lady every day and she does not like me, is it harassment? And then also an additional one, if someone calls you a prostitute, circulating your photo in WhatsApp groups because you refuse to have a relationship with him, is that sexual harassment?
Okay. I'll just start with the most obvious. If someone is circulating your photo, now I don't know the nature of this photo, but regardless, it is tied to, we work together and I refuse to go out with you, and now you're circulating things because of my refusal to have a relationship. In fact, it falls under, and I hope this person is not a supervisor, because then it's still hostile work environment and someone imposing their authority. Number one, it is sexual harassment as well, and warrants being reported. In fact, now these ones for WhatsApp groups, it's amounts also to defamation, So that kind of behavior is also sexual harassment, because in fact it's defamation because they're publishing malicious things also against your person, and you don't know how wide it has gone through. And yes, it is for your organization to also deal with that. Under sexual harassment, carry out an investigation, which will be discussed in a different webinar, and give you the results within a certain amount of time. Yes. If you smile at a lady every day and sorry, it was if you smile at a lady every day and she does not smile back or doesn't like you.
Yeah, she doesn't like me. Is it harassment?
Depends. Now, you see, it's very subjective. It could be, how is that? Has she said, stop smiling at me, please? Or you can see clearly it makes her uncomfortable. You see, also how are you smiling? It's very subjective. Are you smiling by making, let me just say, gestures with your tongue? It depends on the circumstance. And if someone has told you to stop a certain behavior, in fact, that one cannot now, because I don't know the nature of the smile, but if it doesn't have a sexual connotation, you're just making someone uncomfortable. That is harassment. By my own gauging of what you're saying, there's no sexual related conduct in what you're doing, but what you're doing is intentionally harassing someone and you even know they don't like you, but you're continuously making sure that it's a hostile work environment. Yeah. Then if you request information about someone's personal life. Sarah, did I get that one right?
Yes, so someone is always asking, consistently asking about your personal life, including romantic and sexual experiences.
Yes, that is sexual harassment. And it makes you uncomfortable. And here's the thing about sexual harassment. we don't care what your intention was. I was smiling at her and I didn't intend to offend her. I was asking because I was just curious. I didn't intend for her to take it as sexual harassment. The law does not care. The law looks at the victim, the person who thinks they faced sexual harassment. What did they perceive from your action? As I said, what would a reasonable person perceive from this action? I mean, you're asking me about my past relationships, sex life, personal life. I mean, to what end? We're in a business environment. And that's the thing, we're not, by the time someone is uncomfortable, then it can amount to sexual harassment. Yes.
All right. So I'll read two comments, other questions that are related. So in regards to dressing and our current agitation for My Dress, My Choice, should organizations have a defined code of dressing to curb the spread and draw a line within which sexual harassment can be easily identified or isolated? And then another comment says that they fail to understand what is exactly the yardstick that is very offensive compared to another. Failure to clearly define the lines leads to reduced reporting and increased offenders in the workplace. So a lady talking about a man's ass is just as bad as a man describing a woman's ass, as politely as we may put it. Sexual harassment, they feel, is still a gray area. And so they ask, would it be wrong to say that men are sexually harassed by My Dress, My Choice kind of attire?
Yes. I think these are very good points on My Dress, My Choice. Number one way for employers to navigate some of these issues would be to put a dress code. For instance, for us lawyers, we have Law Society of Kenya managing how you dress, color-wise, type of, tops that you put on. But still, that doesn't stop someone from coming. If I say white shirt, I can come with a white transparent one if I'm very determined. And that does bring, you're not the first one to the gentleman who spoke about the yardstick for My Dress, My Choice and whether men are harassed. This same conversation, this same issue of My Dress, My Choice by men being harassed by women dressed however they want always comes up. That you can have a lady who comes to the office with a bra, her bra showing, and she has a big bosom, but still My Dress, My Choice. So you are being sexually harassed. If you are offended, you see, it now depends on the circumstance. You can't just say because you dress a certain way, but remember the what do you call them? The aspects we put of sexual harassment. Let's say the lady comes, she dresses like that every day. She passes, her chest is always next to your face. It is a gray area. And in fact, that's why this story of, this whole issue of sexual harassment needs to be chambuliwad with a very neat-picked sort of situation. There needs to be an investigating team that looks at the situation. I can sit here and just theorize about all manner of situations, but it would be different if the investigating place office comes and looks at it. So yes, it is true. My Dress, My Choice has brought about gray areas within sexual harassment. But remember, that does not stop these people for My Dress, My Choice from not being harassed, because men can also claim they're being harassed. And that's one thing that, let's say, many women do not think about, that the sexual conduct would be, your boobs are out. It is persistent. I have to look at your boobs every day. I have asked you politely, could you cover up? Now, here, that is as basic as sexual harassment can be. Everything is on circumstances. Yes. I don't know if I've answered that question, but this Dress, My Choice, there's no right answer that I can give. it's all about coming into the specifics that you're so offended by the persistent nature of the act that you are unable to work. You are no longer productive at work. So that checklist has to be, do you have to go through that checklist? Yes.
Okay. We'll just take to the last couple of questions looking at the time. So is SGBV and sexual harassment policy, is it one and the same thing? And then a question on what constitutes persistence, especially where the harassment is obvious, such as groping private parts. And is there sexual harassment within marriage?
Okay. Gender-based violence versus sexual harassment. So sexual harassment can be a form of gender-based violence, because remember, one of the types of sexual harassment is, one of the tenets of sexual harassment is physical. So like in the case I gave you, the lady, for refusing to have sexual relations with this man or sleeping with this man in the same hotel room, he boxed her. It comes under SGBV, I mean, gender-based violence, because number one, he did those acts because of her gender. There was violence, I mean, that was sex-based. So it's like what do you call it? Those pie charts that can fall in that middle part, even though they're different. So sometimes it can be on their own, sometimes they interact. Then someone asked, can there be sexual harassment within marriage? That's such a cheeky question. My lawyerly answer would be, I am strictly dealing with sexual harassment in the workplace. And within marriage, can there be sexual harassment? In this definition that I have given, in fact, when it comes now to marriage, it falls under a totally different act. That is intimate partner violence, or what do they call it? There's an act against violence within, or sexually oriented behavior within the confines of marriage. There's an act particularly to that. And it was passed, I think, which year was this? I've forgotten, but that is a different type of ballgame. Yeah, but there can be, of course, sexually related violence and acts within the marriage area. Then we go to persistence. Now, persistence is it can be once, it can be twice. It's all about the person who's sitting to judge whether there's sexual harassment. But what can make one act so egregious or so sensitive that we don't even need persistence? Once is persistent enough, that you went and now here we are moving to rape. We won't wait for you to rape again. You did it once and there was sexual harassment, and amongst a list of other things, but it happened at work. So we're talking sexual assault, sexual harassment, all of them fall within the constant context of marriage. So persistence is very subjective. There's no one line that talks about it has to be 5 times. We have to look at, remember the checklist I gave? We have to look at how serious was this offense? Or yeah, how serious was it? How many people were involved? As in, if 10 people are there surrounding you, calling you bitch, prostitute, or talking about you're a lesbian, you're a homosexual, such things have to look at. That is persistent enough. Yes, I hope I've answered that question.
Yeah, thank you so much, Yvette. Your presentation was well detailed, and I'm sure everyone has learned a lot. Back to you, Nancy.
I'd like to pass our regards to the Law Society of Kenya. Thank you so much for gracing us with some time to sensitize us about sexual harassment in the workplace. Thank you to you, Yvette, for your presentation. It was really, really amazing. Maybe even as we come to the end of the session, you can give us your parting shot, what you'd like the people at KNH to learn in general about this topic.
Yes, thank you so much for giving me this platform and the Gender Committee. I've seen some more questions here, which hopefully I can type up and send later. But as a parting shot is, it can happen to you, not only as a perpetrator, but you can be on the receiving end. And to this, I mean, you have to think about your actions, especially now in the workplace. And on my part, for instance, I'm married and I tell my husband, you need to be careful. Some things you think you're taking lightly, but you're there, think about your intention, why you're there to work. You don't need these suits. So it can happen to you. Be very careful with your boundaries. And I don't mean don't interact with people, but when it comes to sex, be very careful. You can find a lawsuit in your hands. Respect people, treat them with dignity. And that way you will find, once you ask yourself, am I being treated with dignity, with respect? Am I treating someone with dignity and respect? There you can begin to know whether you're falling within the areas of sexual harassment. Yes.
Thank you so much, Yvette, for your really, really, really good presentation. And we'll be having the webinar series on sexual harassment at the workplace every Wednesday. So tune in next Wednesday, 21st July 2021. We'll be having a discussion on how do I report instances of sexual harassment and how do I get protected. And then on 28th, we will have a session on compliance to sexual harassment policy and the safeguards against false complaints. And I know these are among the questions that all of us have. Thank you also to the Medical Research Department for hosting us. As of tomorrow, we'll be having another webinar and we'll be talking about children this time around. We'll be giving an overview of adverse childhood experiences, and we'll be having a certified trainer and psychologist in this forum. Please feel free to join in and listen in. Thank you so much to all of us who've attended. It has been a well-attended session. We've hit the 1,000 mark, which is really, really amazing. And it shows the demand for the knowledge about sexual harassment in the workplace. Thank you so much. For any questions, feel free to ask them now when we have our webinar session on Wednesday about sexual harassment. Again, we will be having our KNH-UoN conference, the 5th International Conference. This will be done in October 27th to 29th. Please mark those dates. And for everyone who, or anyone who has an abstract, you've ever written an abstract, please submit it so that we disseminate the knowledge that we have to everyone. With that, thank you so much. Thank you, Vanessa, also for organizing this webinar session and ensuring that we have the Gender Committee. Thank you all. We've come to the end of the session. Thank you.